Hello, everyone, and welcome to another episode of our Toil Symposium that we're conducting at RSIL. Today, we are very happy to have with us Asad Kiyani. Asad Kiyani is an assistant professor in law at the University of Pretoria and a research associate with the Center for Asia Pacific Initiation at the University of Victoria. Thank you so much for joining us today.
Thanks for having me.
So I read your article on Al-Bashir's continuing immunity before the International Criminal Court. Could you summarize just generally how that operates and talk about it in light of Putin's arrest warrant?
Yeah, absolutely. So the controversy around head of state immunity really deals with a problem that's unique to the International Criminal Court, in the sense that the International Criminal Court would normally have jurisdiction over anyone who's a head of state or a military leader of any kind. They wouldn't be immune from prosecution before the court. And the reason they wouldn't ordinarily be immune from prosecution before the court is because the court's own statute says any state that ratifies this statute, so any state that agrees to this statute, basically agrees to waive all these immunities for heads of state and for anyone else. They're all waived. The challenge with someone like Al-Bashir and Putin is that neither Sudan nor Russia have ratified the Rome Statute. And so it creates this conflict between what customary international law says should happen, which is that their immunity should operate, and what the Rome Statute says should happen, which is that their immunities should not operate. And the conflict comes about in part because the Rome Statute is a treaty, and states have to sign on to agree to its provisions. And Sudan and Russia rightfully say, well, we haven't signed on, we don't agree to those particular provisions. So it created an ongoing saga for over 10 years the International Criminal Court dealt with. And eventually, a couple of years ago, in a decision dealing with Jordan's refusal to arrest the Sudanese president, Omar al-Bashir, the International Criminal Court said basically that it doesn't matter if these other states have agreed to waive head of state immunity in this explicit way. What matters is that that the International Criminal Court has jurisdiction, and when it has jurisdiction, then these immunities are deemed to have been waived. That's really simplifying it in a little bit, but at the same time, it doesn't really deal with the problem. And there's legal arguments as to why that's maybe not a great argument, and I've laid them out as you've pointed out. I've argued this a little bit. But I think the weakness for the International Criminal Court is not the result it ends up with, but how it gets there. The reasoning is more of the problem than the result. Yeah. And I think that's where states have taken issue with it.
Yeah, and the ways in which it kind of equates non-party states with state parties in a way by putting all of this burden, essentially this obligation on party states. Especially we're seeing that in light of Putin's arrest warrant when he goes to South Africa. And it was very interesting to see that the South African Constitutional Court waded into that in the Al-Bashir judgment when it came to the Al-Bashir case, because they effectively said, no, you are bound to hand him over to the ICC under your international obligations. But in doing so, it kind of acted like immunity didn't exist. And we've done some writing on this here, and it's very interesting to see it from some lawyers would argue, yeah, there is an obligation. And then others would be like, no, you can't just take away a centuries-old customary right to immunity, and I believe that state practice indicated by the fact that Bashir was not arrested wherever he went, and Putin is not likely to be arrested. I mean, that's still up for debate. It seems that state practice hasn't got there.
Yeah, that's a really good point. One of the weaknesses in the International Court's reasoning about al-Bashir and the decision of Jordan not to arrest him is that it ignored those kinds of examples. It ignored, for example, that the Security Council wasn't acting to support the International Criminal Court's chief prosecutor when she requested help. It ignored the fact that dozens of states had not arrested al-Bashir when he traveled, that China had voiced their objection to this interpretation of the law, that there were all this evidence of state practice that says, look, you may believe that this is conclusively correct, but not all states agree with you. And most of those states were based in the global south somewhere.
Yeah, yeah. And I think that they're the ones that can have the stick waved at them more effectively than other states. And to look at it from a Pakistani perspective, we access EU trade tariffs through a generalized scheme of preferences plus scheme, which is called the GSP plus scheme. And we are forced to, and I say forced, because we are forced to ratify human rights treaties in exchange for those trade tariffs. And the latest round of GSP plus, they have indicated that perhaps Pakistan would have to ratify their own statute to have access to those trade tariffs. And for a country which, I don't know if you're following the political economic state of Pakistan currently, but at 40% inflation, at an IMF chokehold, currently at the risk of default, it is something that we really can't afford to lose. And at the same time, it's something that as a state and as a sovereign state, we definitely don't really want to be doing. We haven't been in favor of the Rome Statute. We have, well, not to say we haven't been in favor, but we have not wanted to ratify this. So do you think that that helps the court's legitimacy or undermines it? I mean, from the perspective of the Global South, I think it horribly undermines it.
What's really disappointing about this kind of approach is that it really echoes, colonial relations in the Global South.
Yeah.
And I think you can see that through the point that you made about compulsion, that there really is no choice for states like Pakistan, for example, who are in dire economic straits and who desperately need access to, in this case, EU markets. There's a compulsion. There's effectively a requirement to ratify the Rome Statute. And that creates all sorts of burdens and liabilities for Pakistan that have differential impacts for a state like Pakistan. But that's the cost of doing business, quote unquote. There's a precedent for this in international criminal law, which doesn't make it any better, but it does exhibit the range of approaches that are used to try and compel compliance with international criminal institutions. When the newly independent state of Serbia was asked to hand over its former leader, Slobodan Milosevic, to the International Criminal Tribunal for Yugoslavia, the government of the day initially refused to do so. And a court decision was pending when it became clear that about $1 billion in aid would be conditional upon his transfer. He was immediately transferred.
Right.
So that kind of carrot stick approach has been applied in the past, and it's really unfortunate because it doesn't bode well for the future legitimacy of that tribunal. If you were to go to Serbia today and ask people there, particularly in the government, what their view is of that particular tribunal, it's not a very positive one at all.
Oh, right. Okay.
And I think one of the risks there is, obviously the reputation of the tribunal takes a hit, its legitimacy takes a hit. And the ratification itself doesn't guarantee cooperation. It doesn't guarantee any concrete results. And the Al-Bashir non-arrest is a great example of how states go about avoiding their obligations under the statute. There's other ways in which they do it too. And you can look at the lack of convictions at the International Criminal Court as evidence of how states can make sure that they're cooperating without really cooperating.
Right, right. I also think that that's quite evident when it comes to the complementarity provisions of the Rome Statute, because so I think it was Australia recently tried a bunch of their officers for war crimes because they were worried that the ICC would get involved. And yet when you have states with quite low capacity or with, the very standard human rights complaints against them, I doubt that the ICC would take such a backseat approach when it comes to saying, actually, yes, you've proven that you're willing and able to handle these cases yourself. I mean, we can see that with the reopening of the investigation into Afghanistan. There's no way the Taliban is going to be able to prove to anyone that they're willing and able to handle that. But in terms of capacity, it varies a lot.
Absolutely. And that's one of the concerns about the complementarity provision is that it can be interpreted, and some people have argued that it has been interpreted in ways that privilege Western legal systems and institutions, as opposed to particular governments or particular legal systems that are seen to be backwards or untrustworthy.
Yeah.
And the way in which that operates is unfortunate because there's a great emphasis on particular states prosecuting the exact same people for the exact same charges that the International Criminal Court would prosecute them for. Even if they're prosecuted or convicted of other serious offenses or sentenced to long terms in jail, and we saw this in the Ivory Coast, the International Criminal Court will insist that complementarity has not been satisfied. So it's a really strict standard that's applied. And again, it seems to be applied most consistently in respect of global South states. But again, of course, that's in part because the ICC is almost exclusively investigating situations in the global South.
Yeah, and I remember when it came to my LLM and learning about this, we were told that it wasn't always that clear, in the sense that, sure, you can say that there's an anti-African bias, but at the same time, it is African states usually referring people who have just been ousted to the International Criminal Court as well. So, and we were also told that they're they're twiddling their thumbs in the Peace Palace. They want cases. And especially for a court which is costing so much to run, you definitely want cases to be there. So yeah, I thought that was an interesting way of looking at it. But I think that the more time goes on, when I'm looking at the International Criminal Court, I'm just like, there's way too much counter evidence to that.
I mean, there's certainly this argument that self-referrals are why the court has had this African bias. And just to put this African bias into concrete terms, over the first 20 years of the court's existence, from July 2002 to June 2022, it issued publicly at least 47 indictments.
Okay.
Every single one of those 47 individuals was African.
Oh, wow.
In the last year, the court has publicly indicted 5 individuals, 4 of whom are Russian and 1 of whom is a Georgian national who's accused of essentially being a supporter of separatist pro-Russians in Georgia. So it's a pretty high percentage of people who've been publicly indicted who are all African, over 90%. Now, we can say that is self-referrals that are happening. There also has been some encouragement from the court for certain countries to self-refer, and encouragement in the form of, if you don't do it, then we will. Because the court has its own ability to, or the prosecutor has their own ability to initiate investigations of state parties. One of the other concerns about this is something you alluded to, which is, states refer their ousted leaders or cases involving their ousted leaders to the International Criminal Court. And that's one of the other problems with the court, is that it's not just this Western bias that we can try and map onto it. It's also that the court seems to cooperate with some states and some governments and tolerate partial prosecutions within a state.
Yeah.
So maybe there's a war, maybe there's a conflict of some kind, and the government says, well, we'll arrest these guys for you and we'll send them to you and you can prosecute them. But in return, the expectation is that you won't ask for or prosecute any government leaders or government military personnel, something along those lines. You'll let us do that domestically, for example. And so there's this kind of trade-off that seems to happen in a number of cases where you have states understanding, states from the global South understanding they can actually use the International Criminal Court as a tool of domestic politics.
Oh, right.
And so that is its own novel kind of problem at the International Criminal Court.
Yeah, that's so interesting. I actually didn't know about that at all. And it is interesting in terms of the way the court tapes cases as well, in the sense that there's meant to be, so when it comes to Russia and Ukraine, there is now a push for a tribunal when it comes to Ukraine. And I was just looking down the list of those who had signed. I think it was like the former British Prime Minister Brown and his wife had got all of these international lawyers together to sign a letter saying, let's have an international tribunal for Putin and for Russian leaders because of this war. And I was just looking down that list and I was just so disappointed in everyone, if I can be really honest, because I was thinking, and I think that Kevin Heller wrote this in a Needle Talk article where he said you can't ask for one for Putin when you didn't have one for Iraq. And for Gordon Brown, of all people, to be asking for this tribunal, it's just like, you're like, am I insane or is everyone else insane? I can't figure it out. But that very, very selective approach to justice, and the fact that we keep on having actually people come to Pakistan to figure out why the global South is not as anti-Russia in the Russia-Ukraine crisis as they would like us to be. And I mean, I can't go into details of these meetings, but in terms of one kind of looked around and said, how can you stay moral in the face of something like this? And how can you be neutral? How can you morally be neutral in a state like that, in a case like this? And I was like, it is so interesting for you to come and ask us for that when for the past 70 years, we've asked for the same moral clarity on Israel-Palestine. And yet there you say, well, it's complicated. Well, for us, this is complicated. So yeah, just, I'm sorry, that's a bunch of different questions, but just going into the need for an international tribunal for Russia, when we didn't have one for Iraq, where the US still has the Hague Invasion Act on its books.
Yeah, I think if you hit on a number of important issues here that deal with selectivity at the court, but also with international criminal law more generally. So the special tribunal for Ukraine is super interesting, in part because you can look back over history and say, okay, well, where did we have special tribunals or ad hoc tribunals, and where did we not have them? And it's a very short list of countries where we've had them and conflicts for which we've had them. And certainly the conflict in Iraq is not one of them. And there's no special tribunal for Afghanistan either, although the ICC is currently investigating there. So there's some brazenness to this demand for a tribunal now for this particular invasion, but not for the other ones, right? And I think that the voices that are heard and the voices that are amplified when you ask for a tribunal now, in respect of Russia's aggression in Ukraine, it's interesting to look at who those voices are. Like you said, going down that list, we all know a lot of those names that are on that list, and those are the voices that are heard. Right?
Yes. Yeah.
What's also interesting about the demand for the special tribunal is that, in part, it's a product of the failings of Western states with respect to the International Criminal Court. There's no way that the International Criminal Court can have jurisdiction over Russian aggression specifically in Ukraine. The crime of aggression cannot be prosecuted against Russia at the International Criminal Court.
Yeah.
And that's in part a result of how the definition of aggression was agreed upon, and the trigger mechanism for aggression was defined by primarily Western states, who did not want it to be automatic and did not want it to apply to every state. So there's this weird gap now in the International Criminal Court's jurisdiction for that one particular crime. And that one particular crime is obviously the most clear violation of international law that we see in Ukraine. So you need a special tribunal for it because you've actually sabotaged the International Criminal Court's ability to do the thing you actually wanted to do now, right? So there's this unfortunate boomerang effect there that we're seeing playing out now as well.
Yeah, that's so interesting. I had not thought about that at all. So thanks so much for bringing that up. And even when it comes to the way we kind of, I mean, for me, I kind of see it as like brown faces and white faces. So you have an anti-African bias. Let's have a Ghanaian prosecutor as the face of the International Criminal Court. At the same time, I thought she was fantastic. And I thought that she was very aggressive when it came to Palestine, when it came to Afghanistan. And I have like utmost respect for her. And now she's been replaced by a British Pakistani prosecutor who, again, I was very much in favor of. It was just very nice to see that the International Criminal Court's prosecutor would now be a British Pakistani. And then he seems to have had a very politicized tenure so far, and especially when it comes to Afghanistan, he decided to deprioritize American crimes, which I thought was quite shocking. And what's the point then? And even similarly, he's been very aggressive when it comes to Ukraine. And I know that all of this is very political and tied up with funding, because a lot of that comes from the US. So what else can they do? But in terms of enhancing the ICC's legitimacy, enhancing and how it's viewed, especially when it comes to the global south, do you think that approach is working, this kind of tokenistic representation? But also, yeah, I kind of wanted to ask you what you think of the latest prosecutor's actions.
I think you described the latest prosecutor's actions very well. I think in some respects you see great pace, great intensity, great focus. Ukraine's a wonderful example of that. And in other situations, what you see is things slowing down, things being deprioritized, focus being on what Afghani security forces may have done as opposed to what American security forces may have done, or we know they did rather, in Afghanistan. I think that's a fair assessment of what's happening here. And it's in keeping with what's happened in the past with the Office of the Prosecutor. You've seen in the past some preliminary examinations, then investigations drag on for years and years and years. Okay. And you've seen some progress in a matter of weeks. So Nigeria is one example where in 2010, I believe, the preliminary examination was made public. It took 10 years for the Office of the Prosecutor to get authorization for an investigation into what Boko Haram had been doing. And there's still no authorization 2.5 years after the Office of the Prosecutor sought it. And again, it's a question of priorities to some degree. When the UN Security Council referred the situation in Libya around the same time in February 2011, so a year after the Nigeria situation, that investigation opened in March of 2011, and warrants were issued starting in June of 2011. So in a matter of weeks, the investigation happened, and a few weeks after that, or a couple of months after that, you had warrants being issued. And the difference, of course, from us looking from the outside in, is, well, who really wants the Libya investigation to go forward? And how much of a priority is it for which parts of the international community? You can see how the Office of the Prosecutor has slow played some other investigations, right? So we've talked about Libya, we've talked about Ukraine, we've talked about Nigeria. You mentioned Palestine. So in Palestine in January of 2009, it declared that it was accepting the court's jurisdiction. In response, the prosecutor's office said, well, you're not actually a state. So in 2012, when the UN General Assembly said, well, Palestine is a state, the court said, okay, you can submit a new declaration. They rejected that new declaration because it came from the wrong official. They said it has to come from one of 3 officials. It came from one of the wrong ones. Okay. So they accepted the 3rd declaration. It took 4 years to go through the preliminary examination to see if it's okay to open an investigation. Then the prosecutors sought judicial guidance on the scope of territorial jurisdiction. And then finally, in March of 2021, so just over 2 years ago, the investigation was opened. So you can see how the jurisdictional hurdles were such obstacles in that process. Right. Yeah. And again, there's lots of reasons why, and you've alluded to some of them, but you can see the difference in speed in some places, and in some cases you can understand why observers would say, well, this looks really like we're preferring particular political interests over others. It's not just a legal question anymore. It seems like it's a political question that's at play in certain situations. On this question about, does it matter that we had initially a white man as a prosecutor, but then we had an African woman and now a British Pakistani man. I don't think any states really see this as legitimizing the court in any way. In part, that's because the structural forces that align against an individual prosecutor are so strong, it's really hard for that one individual or even their office to overcome them. You alluded to the budget. There's the lack of an enforcement arm. The prosecutor relies upon the states it's investigating in or other states to pressure and compel cooperation. And so in some ways, I don't want to exculpate them or absolve them of all responsibility. In some ways, the Office of the Prosecutor is relatively powerless, which is what makes what Fatou Bensouda was doing all the more remarkable. She's an African woman. She's openly seeking to investigate American crimes in Afghanistan. she does push the Palestine referral further and a little bit faster than her predecessor did. And she ends up being a target for sanctions and legal threats from the United States in particular. And she ends up being frustrated by the judges she's working with in Afghanistan in particular. So she can't actually be that much more effective, even though it seems like she tried in some respects to be much more effective.
Okay, yeah, that's a really interesting look at that. So my final question is one which is related to, but I kind of just want your perspective on this, because you are an assistant professor in the global north, what we call the global north. I know that this dichotomy is very crude, but what advice would you give? Because you're also looking at this from third world perspective, critical perspective. What advice would you give to other trail lawyers who are looking at international criminal law and the functionings of the International Criminal Court? And what advice would you give to lawyers in the global south who are looking at this and who are advising their states about this?
Wow, that's such a huge question. Let me start with the TWAIL part first. For TWAIL scholars, there's a real tough decision to be made here, and that is, where do you sit in relation to an institution like the ICC that has rendered itself less and less legitimate over time, it seems. Initial waves of optimism have really faded around the court, and not just because of this Western bias or anti-African bias, just a sheer lack of convictions. 10 people have been convicted, 5 for international crimes, and 5 for tampering with witnesses and presenting false evidence. That's it in 20 years. And we're talking hundreds and hundreds of millions of dollars have gone into the court. And that's the return that people have seen.
That's 10 convictions at the ICC.
10 convictions at the ICC in 20 years.
Okay.
And so that's not the only way in which you can measure a court's performance.
Yeah.
But it doesn't help when you are the criminal court for the world, and you have all these situations referred to you, and you can barely muster a conviction every couple of years. So that's another aspect of the problem here. So ineffectiveness alongside this, what looks like a Western bias, alongside what I mentioned earlier, which is that there's divisions that the ICC accepts and tolerates within its actual cases, within its situations that it investigates, rather. So again, you can see the global south, you can see some governments playing politics through the court,
right,
cooperating to ensure their enemies are prosecuted, and not cooperating when their own men might be prosecuted. So that creates its own challenges to the legitimacy of the court. And if you're a third world approach to international law scholar, then your primary commitment is supposed to be to the well-being of the ordinary peoples of the third worlds. Not the states themselves, not the elites of the states, but to the ordinary peoples. So the question you have to ask yourself is, how does this institution effectively serve the ordinary people of the third world? How would ordinary Pakistanis, the ones who are struggling, the cost of gas, the rolling blackouts, inflation, how would they be served by Pakistan's participation in the International Criminal Court? That's the question that has to be answered by every TWAIL scholar for themselves. If they believe there's some future with international criminal law or the International Criminal Court, there's lots of good legal work that can be done. And that includes things like, let's define the purpose of the International Criminal Court. Some have argued that what really could be valuable for the International Criminal Court is that it doesn't, in fact, prosecute all sides to a conflict. It only prosecutes people affiliated with the government, with the people in power. And it leaves the other prosecutions to national jurisdictions. It says, okay, you guys can prosecute your enemies, we'll prosecute you. Right. That's the gap it can maybe fill in. Or you can work on doctrines of complementarity. How do we rethink complementarity so it isn't so apparently biased against non-Western legal systems? So it doesn't have this incredibly strict standard, so that it doesn't allow Western states to do a few prosecutions of low-level soldiers and get away with having no one else charged with anything, no one more senior than an infantryman charged with offenses. There's lots of work that can be done on defining international crimes, on working to change the trigger mechanism for aggression, and even learning how to set up domestic prosecutions using international law domestically. So there's lots of work for 12 scholars to be done. But again, the question is, how will this help the ordinary person in Pakistan or Rwanda or China, wherever they may be?
Right.
You know, I would like to think that government lawyers will ask themselves the same questions, although I understand that's not always the case. Sometimes loyalties are divided when you work for the government. What I would say in that context, that it's important for government lawyers to think about what the precedent is that's being set by each decision in respect of international criminal law or the International Criminal Court. One of the reasons why the Al-Bashir arrest and immunity decision was so important was because it seemed to really say something about the power of the UN Security Council to override the sovereign decision of countries to not ratify a treaty.
Right.
Sudan did not want to ratify the treaty. They're still bound by it, right? Russia didn't want to ratify, and in lots of ways is, theoretically at least, bound by it. Same with Libya. That's an important consequence of what seems like a nice idea, which is arresting and prosecuting someone who likely ordered some serious international crimes to take place, likely knew about genocide taking place. At the same time, in order to get jurisdiction over him, we have to sacrifice something really fundamental to third world states, which is an important dimension of our sovereignty.
Yeah.
Right? So there's something really important that's lost there. So weighing those trade-offs, I think, is something that government lawyers in the Global South in particular have to be attentive to. What does it mean to refer this case? What are the possible consequences and repercussions for us down the road? I think that's something that has to be kept in mind. And not when I say us, I don't mean the individuals who might further be prosecuted, but I mean for the state's position and its own sovereign authority, which is of fundamental importance to all states, but particularly states that have gone through the colonial encounter.
Right. Yes, definitely. Yeah. And I really like the measured way of looking at it, which is, this is a great thing, but what is the trade-off for us? And that's really helpful. And I think that's gonna play in my mind when we're further working on stuff like this. So thank you so much for taking out the time to join us. I think this is I really enjoyed this discussion. I feel like I learned so much. So thank you so much. And thank you to everyone who watched at home. And we hope you tune in for future 12 Symposium episodes.